2, 1.
Oh yay, oh yay, oh yay. This Honorable Court of Criminal Appeals of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Welcome to the second day of the February docket, Court of Criminal Appeals for the Western Section. On the panel today are Judges Camille McMullen from Memphis, Judge Ross Dyer from Memphis. I'm Kelly Thomas from Maryville. We appreciate the assistance of our Supreme Court clerk, Mr. Hibner, and our technician, for lack of a better word, from the AOC, Mr. Morgan. Without their assistance in contacting the lawyers and setting all this up, it wouldn't be happening. So thank you very much. You'll have 20 minutes aside. In the first case, I presume both counsel are going to argue. Whoever's first, if you will tell me how the time will be apportioned, then I'll be able to keep up with it. And also let me know if you want to reserve any time for rebuttal. And the appellants will have a combined 20 minutes, as will the state. And hopefully then I'll be able to keep up with it. Are there any special settings this morning, Mr. Clerk?
No, Your Honor.
If not, then call the first case, please.
State of Tennessee versus Tony Thomas and Laronda Turner.
All right, on behalf of the appellant.
Good morning, and may it please the court. My name is Harry Sale. I'm with the Shelby County Public Defender's Office, and I'm representing Mr. Tony Thomas in this appeal. Co-counsel and I have decided to split the time 10 minutes each. And if it please the court, I'd like to reserve 1 minute in rebuttal.
Okay, so it's 10 minutes each and you want a minute for rebuttal.
Correct.
All right, sir, thank you. Go ahead.
Your Honor, Mr. Tony Thomas and Laronda Turner were charged with and stood trial on and were convicted of 3 counts of first-degree murder in the deaths of Anthony Isom, Michael Glover, and Chastity Springfield. Anthony Isom and Michael Glover were then former or perhaps current vice lords, and this, according to the state, was a gang killing. Miss Chastity Springfield was, however, an innocent bystander. She was on a date with Mr. Glover. They were convicted of all 3 counts, and but the third person who was indicted was DeMarco Hawkins. He did not stand trial. He decided to cooperate with the state and ultimately testified at trial against Mr. Turner, Ms. Turner, and Mr. Thomas. The state's case effectively hangs on the testimony of Mr. Hawkins. It depends almost solely on that, and yet Mr. Hawkins is a utterly unreliable witness. Prior to trial, counsel for Mr. Thomas filed a Brady motion and asked specifically for any statements given to the prosecution that contradicted former accounts and statements given to the Memphis police, and any facts that might have been added to any statements given to the police. There was a hearing on that motion, and but there was no compliance with it.
When you say no compliance with it, do we know exactly what statements you were asking the state to provide? I know that generally you allege you wanted any inconsistent statements. Was there any proof that inconsistent statements existed prior to the co-defendant Mr. Hawkins' testimony?
Well, there were, I think the reason for this was primarily
I was really looking for more so, Mr. Sale, just exact statements, because you kind of put the state in a difficult position when you allege that they have withheld something they were ordered to provide when, if it didn't exist at the time.
Well, at that point, they were not asking for a specific statement. They were asking for any statements or any contradictions between, because his story, his accounts to the police and to the prosecution was morphing all the time. And so there were clearly inconsistencies in his statement. And I mean, his account of what happened, including starting with, well, actually, it started before he was ever a suspect. He was texting a former girlfriend, lying and bragging about killing someone that he hadn't killed, and also killing Mr. Anthony Ison, which he
So
may
these
have done.
these statements that you just said, the bragging to the girlfriend, that was the kick statement. That's alleged to be involved with another issue.
Right.
Other than that, were there other inconsistent statements that you are hanging your hat on with this issue that the state did not provide? Because I think it's pivotal. I was trying to go through the record to see there was a hearing on this issue, and apparently the defense hotly contested this issue, and the trial court ordered the state to provide you with inconsistent statements. And I was looking for compliance with that, or standing on that prior to trial by the defense, that you had not been provided with the statements that you alleged to be inconsistent. But I didn't see any of that in the record.
Well, the actual basis for our contention is the basis for the violation of Brady actually occurred. We didn't even become aware, or trial counsel didn't become aware of it until he testified at trial to something that he had never mentioned before.
Okay.
And the fact that they were suspicious that there would be inconsistencies because he kept changing his story.
Well, how was the state supposed to provide you with that information if it happened at the time that he was testifying?
It didn't happen at the time he was testifying. That's when when counsel became aware of it. It happened in at least three proffer sessions with the prosecution, where he indicated that, contradicting his former statements, that Miss Laronda Turner never entered the house and didn't shoot anybody. When he got on the stand, he testified that that indeed was not true, or at least his account then was that Laronda Turner came in, went to the back room, took a gun from Mr. Hawkins, and shot at the innocent bystander, essentially, which turns out to be even more important than it appears at the time, because Mr. Thomas's sentence was increased because of the fact that she was an innocent bystander. But that's the trial counsel only became aware of that, the existence of that, at trial. But the prosecution knew before that that the story had changed, and what he was saying.
Do we have something in the record that will tell us that?
Well, now we filed a motion. She brought up the Brady issue at the motion for new trial, and the court asked her, "Do you have any proof?" And she said no. She filed a notice of appeal, and then about 2 months later, acquired the affidavit of Mr. Hawkins' attorney, to the effect that during these proffer sessions, his client had told the prosecution that account wherein Miss Laronda Turner entered the house and shot at the.
All right, now I get where I understand now where it's coming from.
And it's not, well, and so, of course, she later filed, when he had asked, did she have any proof? And then she filed a notice of appeal. And then later she got the affidavit and filed a motion to supplement the record with the affidavit of Mr. Hawkins' attorney. He denied that, and the trial judge denied it. We appealed to this court to include that, and this court sent it back for him to have a hearing, or for him to decide on the merits whether that should be included in the record. He didn't have a hearing.
I guess the trial court was concerned that it wasn't presented at the initial motion for new trial.
He said he didn't have jurisdiction, essentially, but yeah, he said that affidavit didn't exist when he was considering the motion for new trial, but essentially it was a jurisdictional argument, and of course there's joint jurisdiction over the record. It seems, the way I read that and so I checked the record before it came up, and our motion, which had attached to it the affidavit had been detached from the motion. So we were stuck with some way to at least bring to the court's attention what was at issue here. And so I attached it to my brief. And so that's
So the
that's where it can be
affidavit,
found. It's not in the record, but
the affidavit's not in the record?
it is not in the record. It's in my brief, and because it seems to me that that's an appealable issue, because while he has he's the ultimate authority on that, those things that go into the record have to be, it can be added, and if it provides a complete and accurate and fair account of what happened at the trial court. And we believe that affidavit does. So
Okay,
absolutely, I'm sorry.
Speak to the effect of the, I guess, the impeachment of, is it Mr. Hawkins? Because
Correct.
I understand, Mr. Sale, that he was heavily impeached as a co-defendant in this case. So even if we accepted the affidavit as true, which we've already rejected it, even if we did accept it, what's the effect of this information on the case? Because the whole point of it was to impeach a co-defendant, correct?
Well, yes, certainly there was that aspect of it, but also it affected, apparently, trial counsel argued that there was some hairs, long hair found in the victim Glover's hands as he was dead in the closet, where Chastity was also dead in that back bedroom. And there was a pending motion to have DNA analysis done. And it was about, I think it was a week before trial, but it was very close to trial date, when she could have, had that been known to her at that time, she would not have waived or withdrawn the delay of the trial in order to have the DNA analysis, because she said it would have further impeached Mr. Hawkins. Also, there was an apparent conflict between Ms. Turner.
But Mr. Hawkins had already put your client inside the house, correct?
Oh, he was inside the house, but actually, there's, the account was that in the back room when they first went back to the shot, they walked across the street, according to Mr. Hawkins, knocked on the door, and when Mr. Isom answered the door, they shot him. And Mr. Glover was in the front room, but ran to the back room, and Mr. Hawkins ran to the back room and shot him. And then Mr. Thomas Mr. Hawkins followed him back there, and they shot Mr. Glover multiple times, and he was dead in the closet, but there's no mention of whether Miss Chastity Springfield was shot. No direct statement that, yeah, and Tony shot him. So it raised the issue of whether he actually was guilty of actually shooting the most sympathetic victim. So it would have gone to sentencing also. And that did come up in sentencing when the judge characterized her as an innocent bystander. And he gave Ms. Laronda Turner 3 counts of murder, life sentences run concurrent. But Randy,
then some.
pardon me?
I said, we're out of time and then some.
I'm sorry.
I will still give you a minute of rebuttal after counsel for Ms. Turner, well, after the state argues. And Ms. Holland, you have your 10 minutes.
Thank you.
Do you want to have any rebuttal time reserved?
Yes, Your Honor. Good morning, Your Honors. Opposing counsel, may it please the court. I'd like to reserve 2 minutes for rebuttal, please.
Okay.
My name is Josie Holland, and I represent the appellant, Laronda Turner. Mr. Sale has addressed the Brady issue in this matter, and so I'll be moving on from that. While all of the issues that we discussed in our brief are important, today's argument is going to focus on the heart of the matter, which are the due process violations that occurred before and during trial. First, we're going to discuss the failure of the state to preserve material evidence. And if this honorable court should agree that material evidence was not preserved, this honorable court must vacate the convictions and dismiss the charges. Second, we'll talk about DeMarco Hawkins's printout of his Kik message. Kik is an app used on cell phones for communication. The trial court, sua sponte and without objection from the state, excluded this printout, which contains some rather nasty language. And then finally, we'll discuss the jury instructions, which were overly confusing and also shifted the burden to Ms. Laronda Turner to prove her innocence rather than demanding that the state prove its case beyond a reasonable doubt. The state did fail to preserve material evidence in this matter. There were 2 photo spreads, a photo spread D and E, which were mentioned in the discovery. And the state also admitted during the course of the trial that these had not been preserved. These photo spreads were shown to 2 witnesses, Terry Jennings and Tony Reed. By not preserving these photo spreads of other potential suspects, the state deprived the defense of the ability to prepare for its case.
If I understood the briefs correctly, the photo spreads that were not preserved, testimony came in about them, and this is my understanding from reading it. The testimony was at least one, if not both of the defendants were in those photo spreads and were not identified by the witnesses. So if that's the case, if there's testimony that we showed them a photo spread, the defendant was in the photo spread, and the witness did not identify anyone, what's it matter if the photo spread is shown to the jury or not? The jury got what you wanted the jury to hear, and that is witness X got a photo spread with my client's picture in it and couldn't pick anybody out. That's the proof you want. That's what you want the jury to hear. What does it matter if you have the actual pictures or not?
Well, Your Honor, this is favorable evidence. It's not enough for the jury just to hear it. The jury should also see it. And by denying the defense the ability to present it, to say, here is a picture of Ms. Laronda Turner, and you could not pick her out, to not be able to use that in closing, to not have that go back with the jury, that does hurt the defense.
But you got to do that. You just didn't get to show them a piece of paper. I mean, you got to say that witness testified that they saw a photo spread that the defendant was in, and they didn't pick her out. I don't see I'm having trouble seeing how your due process rights were violated when the proof you wanted, what you wanted the jury to hear, came in. I don't know what the picture adds.
Well, the state was under a duty to preserve the evidence, and in State v. Ferguson, the court mentions that the State v. Ferguson contemplates a DUI video where there had previously only been testimony from the police officer. In that circumstance, Your Honor, the court mentioned that though the video might not have provided much additional evidence, the state was still under a duty to preserve it and to present it to the defense in pretrial discovery. And we would argue that this failure to preserve does violate Article 1, Section 8 of the Tennessee Constitution, as well as the 5th and 14th Amendments. Our second issue for the duty to preserve concerns DeMarco Hawkins' cell phone. Now, there is a factual dispute here because the state says that they did not have DeMarco Hawkins' cell phone. However, the kick message, the printout of the kick message was obtained, and there was significant discussion during trial about how Mr. Hawkins had left his cell phone at one location to make it appear as if he were there when he was in fact at the Lake Grove house. So it seems that even if the prosecutors never had the cell phone, an agent of the state, a police agency, would have had it at some point. And this cell phone could have provided very valuable evidence to the defense, both at trial and simply for preparation during trial. Moving next to the question of the printout of the Hawkins kick message.
I want to go back to the cell phone. What's the proof that the police had the cell phone?
Your Honor, first of all, they were able to obtain printouts of the kick message. They were able to have a printout from an app which would have been on Mr. Hawkins' cell phone. Also, there was extensive discussion of—
Did they say they got that from Mr. Hawkins, or did they get that from the person he sent the message to?
It is unclear where that information comes from. But given that the state also had information regarding the geopositioning, the GPS of the phone, it seems likely that at some point they either had the phone itself or at least they had the data from the phone. And that should have been preserved for the defense's preparation.
But can I get the geopositioning from the cell company? I don't need the phone.
That's possible, Your Honor. I believe there was also testimony from Mr. Hawkins himself that his cell phone had been taken. Now, Mr. Hawkins is unreliable, but that the proof stands as it is, Judge.
I know you're short on time, Ms. Holland, but again, can you tell me what the relevance? You're citing the geopositioning. All of this goes to Mr. Hawkins, correct? And he's implicated himself in terms of where he was at the time of the murder. I'm trying to get what you feel to be exculpatory for your client from the cell phone.
Your Honor, Ferguson does not contemplate just exculpatory evidence. It contemplates evidence that could be favorable to the defendant. If the cell phone had been preserved, there could have been a lot more information about the structure of the organization with which the individuals were involved, who else DeMarco Hawkins might have spoken to that night.
In the structure of the Vice Lord organization?
The structure of the Vice Lord organization, Your Honor.
Who else he spoke to, you can get from the cell phone records. You don't need the actual phone.
Your Honor, without the phone, it would have been difficult. We would not have been able to obtain the messages themselves from the cell phone data. In order to pull the messages from the phone, we would have required a forensic analyst to have done so. But about Hawkins' kick message, the trial court committed non-structural constitutional error when it excluded the printout of Hawkins' kick message. More than that, though, when the trial court did this, when it excluded this printout of the kick message, it acted more as an advocate rather than an impartial arbiter. And the Tennessee Constitution instructs that judges may state the testimony and declare the law, but should not charge the jurors with respect to matters of fact. And the trial judge here called Ms. Case's attempt to enter such evidence inappropriate in front of the jury. And in saying it's inappropriate, the jury might not understand that that means rules of evidence. The jury could have believed that the trial judge was calling Ms. Case inappropriate.
You're getting into your rebuttal time now.
We are, Your Honor. I'll reserve and pass to the state.
Okay, thank you. On behalf of the appellee.
Good morning, Your Honors. May it please the court, Samantha Simpson on behalf of the state of Tennessee. Your Honors, this court should affirm the defendant's convictions. They have failed to establish that the state committed a Ferguson or Brady violation. The evidence is clearly sufficient to support their convictions. The exclusion of co-defendant Hawkins's kick message was not plain error, and the trial court properly instructed the jury in this case. Turning to the defendant's Ferguson allegation issue, the photo spreads here, as Judge Dyer noted, the defendants received all exculpatory and were in possession of all exculpatory evidence obtained from the photo spreads. And in the case of State versus Sanders, which this court decided in 2016, we have a case that is very factually similar to the one that is at hand. In that case, the defendant claimed that a photo spread with another suspect could have been used for impeachment value. But this court noted that the victim did not make an identification from that photo spread. Additionally, this court noted that that photo spread was not significant because there was a duplicate in the police database. Additionally, this court looked at the fact that there was sufficient evidence to support the convictions and concluded that the defendant received a fair trial. Here, the state provided the defendants with the detective copies of the photo spreads. And the difference between the detective copies and the actual photo spreads is only the fact that the detective copies listed the actual names of the people on the photo spreads. Thus, the defendants had the exculpatory value evidence that it could glean from these photo spreads. The fact that, as Judge Dyer noted, the witnesses Jennings and Reed did not make identifications of either defendant.
And also, there's not a misidentification, correct? They just picked no one.
Yes,
Is that
Your Honor.
right?
Yes, Your Honor. They did not identify anyone in any of the photo spreads.
Okay.
Turning to the Mr. Co-defendant Hawkins' cell phone, it is unclear whether and when the state possessed the cell phone. At the various motion hearings, the state asserted that the Memphis police had searched for any record of the cell phone and they could not find any evidence. No evidence logs, no actual physical cell phone. And as opposing counsel noted, the state did have data from the cell phone. And whether this was obtained from a subpoena was not entered into evidence. That could have been how the state got that information. But it is clear that the state turned over the records that it had from the cell phone. Thus, Ms. Turner possessed the kick message prior to trial and was, as she argued, was seeking its admission. So she had that evidence prior to trial and was able to use it in her trial strategy. Moreover, she could have obtained the records herself via subpoena. And unless this court has any further questions regarding the alleged Ferguson violations, I will turn to the Brady issue. In this issue, the state disclosed all favorable facts from the session. And Judge McMullen, I would like to address your question about what exactly the defendants were seeking and talk a little bit about the timeline. The defendants filed their motions for discovery back in 2017. And on February 14th, 2019, a motion hearing was held after the proffer sessions. And it was at that motion hearing where the trial court determined that no Brady violation had been held. And then the trial was held in end of April and beginning of May of 2019. Here, the state disclosed any favorable facts from those proffer sessions. Favorable evidence is any evidence that could be used for impeachment or to give significant aid to the defendant's case. And here, the state disclosed to the defendants any information that contradicted with co-defendant Hawkins's initial formal
Did
statement.
they disclose anything? Did they disclose anything consistent with the trial court's order?
Are you talking about in general or specifically from this proffer session? From the proffer.
Did they disclose after they filed their motion seeking Brady material from the proffer sessions, and the trial court said, hey, you need to turn over whatever inconsistent statements that Hawkins gave, the statements that were inconsistent with his statements that he gave to MPD, turn it over. Did the state turn over anything?
Yes, Your Honor. It is unclear.
And where is that?
That's an issue, Your Honor. The proffer sessions were not recorded, so there was not a transcript or a written statement or an audio recording that the state could have disclosed. So the state's position is that they did turn over information, prior inconsistent statements of Hawkins. Yes, Your Honor. It is unclear specifically how, whether it was by email or verbally, but the state asserted that it disclosed to the defendants any contradictory information. So anything from the proffer sessions that contradicted his initial statement.
Okay, but you're lumping it in a general sort of kind of thing. What I'm trying to avoid is we have this general just assertion that we did what we were told to do, and then we don't have any specifics.
Yes, Your Honor, there's not a specific document in the record detailing exactly what facts were disclosed. The state just asserted in general that it disclosed any contradictory information. And following that assertion, the fact that co-defendant Hawkins, the fact that in his initial statement, he said Ms. Turner's involvement was merely as a lookout and as a planner of the murders. And then in the proffer sessions, he stated that she shot Ms. Springfield with his gun. So the fact that, that is a contradictory fact. So that would have been disclosed to the defendants at that motion hearing or before. Whenever
You're saying that would have been, so what they're saying is, and they went so far as to get the lawyer who represented Mr. Hawkins during the proffer sessions to testify that this was inconsistent. Okay, so now I understand that there have been difficulties getting that information in, but they're saying that was never provided to them prior to trial. And what you're saying now in oral argument is that it was.
Your Honor, as far as the record reveals, the state disclosed any contradictory information, and that would have been contradictory information. Additionally, the defendants were able to thoroughly cross-examine Mr. Hawkins about the inconsistencies between his formal statement and the proffer sessions. They were prepared and able to do that at trial.
When you say that the state disclosed all that, what is the source or the basis for that assertion? Where did it come from?
Counsel's statement at the motion hearing. They did not admit a particular document establishing that.
Okay, so it's in the transcript from the motion hearing.
Yes, Your Honor. That's
and when they said that, did the defense counsel dispute it?
Not that I recall.
Okay, but we can look at that record. We can look at that record and see, right?
Yes, Your Honor, of course.
Okay, thank you.
And co-defendant Hawkins openly admitted that he did not initially tell the Memphis Police Department about defendant Turner's involvement. So that information came out at trial. Additionally, the proffer statements were not exculpatory. Ms. Turner was already implicated in the formal statement and was just as culpable as defendant Thomas under the theory of criminal responsibility. And finally, the proffer statements were not material. The indictments gave the defendants notice that the state would present evidence of defendant Turner's guilt under a theory of criminal responsibility or a theory of direct responsibility. And Ms. Turner could have pursued DNA testing or declined to waive the apparent conflict at any time regardless of the theory, but chose not to. Thus, the state did not commit a Brady violation in this case. Regarding the sufficiency issue, I will stand on my brief and quickly to address the kick message. Here, the defendant waived this issue because there was no contemporaneous objection. And at trial, the trial court ruled the message was inadmissible as hearsay. The defendant did not raise a constitutional argument at trial. Thus,
how was she supposed to object?
Your Honor,
To her own offer of evidence when the trial court interjected.
I understand the difficulty. The trial counsel could have asked to, for the purposes of making a record for appellate review, asked to make an objection as a sidebar at that point to preserve the record. And under a plain error standard of review, it's clear that there was no breach of a clear and unequivocal rule of law because this was an out-of-court statement that the defendants sought to introduce to prove that of co-defendant Hawkins's involvement. And the state will also rest on its brief as far as the jury instructions issue. And then I see my time is about to expire unless this court has any other questions.
I have a question about the jury instruction.
Yes, Your Honor.
I recognize that at different points during the instruction, the trial court tried to explain these are two different cases, these are two different defendants. But is there not just a better way to do the instruction than the way the trial court did it? I mean, why can't you, if the way we perceive these things is that defendant Turner's case and defendant Thomas's case, while we're trying them to get together, are two separate trials. Why don't we give two separate jury instructions so as to not run the risk of confusing the jury?
Your Honor, that could have been a possibility, and I can't speak to why the trial court didn't decide to do that. But in the case of State versus Harbison, the Tennessee Supreme Court approved of very similar instructions as to the ones that the defendant used. In that case, there were, again, multiple defendants, and the trial court said that use language such as any evidence which was limited to a particular defendant should not be considered by you as to any other defendant. You can acquit all or convict all, or you can acquit one or more and convict the others. So the appellate courts in this state have approved of similar language, and thus the jury instructions were proper.
I guess what bothers me is the statement in your brief, and in that the trial court offered to use a different instruction that was clearer. Well, and that's not, you don't have that in quotes, but I'm assuming he made some statement similar to that. It wouldn't be in your brief. And I guess my point is, if the trial court recognized that there might be a clearer way to instruct the jury, why don't you go with the clearer way of instructing the jury?
I don't recall that the trial court had an alternate ready. My impression of the record was that the trial court was just offering if the parties wanted to work out different instructions.
And they didn't ask for that. If I read your brief correctly, they didn't ask for a clearer instruction at that point, though, did they? Or did they not?
I don't recall specifically what the response was at that point. I would have to refer to the record. But the trial court instructed the jury here to consider the defendants separately. The trial court instructed that the defendants were presumed innocent and that the state always had the burden of proof. And on appeal, this court must presume that the jury followed those instructions. Thus, the burden of proof was never shifted to the defendants. It was clear to the jury that the state always had the burden of proof.
Okay.
And unless this court has any further questions, the state asks that this court affirm the defendant's convictions. Thank you.
Right. Thank you. Mr. Sale, rebuttal minute.
You're on mute, Mr. Sale.
You're good.
All right. With regard to the missing photo spreads, there were to Judge Dyer's point, the inability to identify anybody from those photo spreads was available to him. However, there were actual photo spreads that were missing, and the judge even referred to it as being not up to par, their handling of those things. And so the question arises, and Ms. Case raised these at a hearing, was who in her motion, who viewed the video, those photo spreads? We'll never know. Who was in the spreads? We'll never know. And what were the results? We'll never know. And so very much like the videotapes that are missing and mishandled, we don't know what's in those things. And that calls for a Ferguson violation, it seems to me. And so I just bring that point up. And also with regard to the state turning over the results of the proffer sessions, I still say that there is no, and the record will not reflect that the specific things that came up at trial regarding Miss Laronda Turner's role in the shooting, those did not come up. I mean, maybe they did turn over some things that they interpret as having been contradictory, but that's their interpretation. But those statements were not turned over or made available until he testified. And so, and that's
All right, sir. Thank you. On behalf of Ms. Turner.
Yes, Your Honor, thank you. Identification was a crucial issue here. Terry Jennings, who is arguably the only disinterested witness, said that that night he only saw 2 men. It was alleged at one point that Ms. Turner may have been a lookout. The state argued that she was a planner, but that was never mentioned that she was involved in planning this. It was only mentioned that she might have been a lookout. But given the crucial nature of the identification, that makes that evidence all the more important. Also, with regard to the state's argument as to waiver and Miss Case and the kick message, what else could Miss Case have done at that point other than stoke the ire of the judge? It's not as if when the judge said, "You can't turn this in," Miss Case said, "Okay." She fought him on it. She contemporaneously fought him on the issue. It's raised in paragraph 5 of the motion for new trial. This judge should not have sua sponte and without objection from the state excluded this printout of the kick message. For the reasons stated in our brief and for the reasons argued today, Your Honors, we would ask that this honorable court vacate the convictions and if not dismiss the charges, then at least remand for a new trial where due process will be honored.
Thank you. Thank you for your arguments.
This honorable court is now in recess until 10 a.m.
May I be excused, Your Honor?